housing in New York. We have rent control is the first, and rent stabilization being the other. So these are the two regulatory schemes that are that cover the city's affordable housing stock. And these can be traced back to before the end of World War II. All right, when the federal government first imposed rent freezes. And as you're going to see in this lecture, these particular government impositions in the terms of rent freezing and holding of certain rents really happened because of the wars. So you have your first one here. It's 1942. You were going back to World War II. And to counterbalance the inflationary pressures that were caused by the nation's war machine, the illustrious President Franklin D. Roosevelt signed the Emergency Price Control Act into law. And this is what froze New York City rents during that period. Okay, then you had the following of the normalization of the economy. After World War II, the federal government allowed the EPCA to naturally expire. And then we get into the Federal Housing and Rent Act of 1947. That's the FHRA. Okay, so let's talk about rent control first, right? Which is the first scheme that we've talked about in which the government has a mechanism to regulate housing here in New York. And if you look at the FHRA, the rents that were charged for apartments in New York City that were constructed prior to February 1st, 1947, were made subject to rent control. All right. And what does rent control mean? Everybody always asks. And remember, you only have about 1% of the city's housing stock is still covered by rent control. And you're going to see why in a minute. Right? Because they cover apartments that were constructed prior to February 1st, 1947. These all fell under the rent control scheme. All right. And that's why we don't have that many left, because this is the first type of regulation and it happened back in 1947. So that's what you're looking at. The year marker is the initial occupancy date, February 1, 1947. And that was adopted by the city's Emergency Housing Rent Control Law of 1950. And it remains to this day the determinative factor in establishing rent-controlled housing accommodations in the city. Okay, and as I said before, there's only about 1% of the 1 million apartments that are subject to rent regulation are still rent-controlled. So it's a very, very minuscule portion of the pie chart. All right, so now let's get into the second aspect of regulation, which is rent stabilization. Okay, and this is what you're dealing with. When you're talking about rent regulated housing, you're typically dealing with the million or so apartments that are still subject to rent stabilization. Don't get me wrong, you do, and I do in my practice, come across rent controlled apartments quite often, but you know, there are not many left. So the grand scale, I would say, of the practice over rent regulated housing deals with Roman numeral 3 here, which is rent stabilization. So we have in 1969, because of a steep rise in inflation that was caused by the Vietnam War. See, here's the war marker again. It's always war that causes inflation that then impacts housing and compels government to do something. Here it's the Vietnam War. So we're in 69. There's a precipitous decline in local housing production. And this is when the city passes its first rent stabilization law, known as the RSL, which we still have to this day. And the RSL established limits on the rents that owners could legally charge tenants in buildings that contained more than 6 apartments that were constructed after February 1st, 1947 and before March 1969. Okay, so this is how you get into rent stabilization, right? 6 apartments, more than 6 apartments, and after February 1st, 1947, before March 1969 construction. So if you meet those two mechanisms, if you will, your apartment will be subject to rent stabilization. So once the RSL went into effect, 400,000 units instantaneously became subject to rent stabilization. And in addition to the rent stabilization law, that legislation created different agencies. The Rent Guidelines Board, which establishes uniform applicable rental increases for renewal leases and new tenancy. The Conciliation and Appeals Board, the CAB, which handled tenant-related complaints. And the Rent Stabilization Association, RSA, right? That promulgates the rent regulation code. And under the RSL, if owners fail to join the RSA and comply with its code, their units would be placed under the more stringent rent control regulation. Okay, that was done to force these owners at the time of initial inception of the RSL to follow the mandates under the RSA. Otherwise, their units, instead of being subject to rent stabilization, would be subject to rent control. And again, they had more stringent guidelines if you fall under control. And in fact, the rent controlled rents tend to be far less than the rent stabilized rents. So it's a gut punch to to landlords. It was at that time. And then you have this mathematical formula that applies to those units that fall under rent stabilization law, right? You have your adoption of a maximum base rent. It's called the MBR. That comes under Local Law 30 of 1970, and it adjusts for every 2 years to reflect market conditions. And it computes a maximum base rent by taking into account the amounts required to operate the units while allowing for owners to realize a return of 8.5% on the assessed value of their units. The rent increases under the MBR were capped annually at 7.5% and were applied until the MBR was reached. And then in order to qualify for rental increases, owners had to provide essential services. That's true to this day, right? You have to keep the building free from major housing maintenance code violations and invest required sums of rental income for operation and maintenance of the buildings. All right, so here we go. This is the big distinction. The big difference between rent stabilization and rent control is that in rent stabilization, you have a comprehensive rental adjustment framework, and it's governed by statutorily created bodies that are designed to readily adapt to fluctuations in the housing market and the local economy. Okay, and conversely, rent control, as we saw earlier, is solely pinned on a date if it's constructed prior to February 1st, 1947. Okay, so now we get into the Emergency Tenant Protection Act of 1974. You have this continued mountain inflation from the Vietnam War, coupled with the deregulation of many units. That happens between 1971 and 1974. Here it's in parens. You have approximately 300,000 rent-controlled units and 88,000 rent-stabilized units at this time. So that gives you sort of a snapshot of the volume of the apartments and how they fell under the two rent schemes. All right. So then in New York City, the housing market, again, in the early 70s gets rocked by sharp increases in rent. You have a lot of owners trying to seek more for their apartments. New York City is, the hub of commercial lending, commercial transactions, really at the forefront and the center of the earth, if you will. So in the early 70s, you have that coming of age era. Landlords, the prices are skyrocketing all across the city. And so the landlords, rightfully so, are trying to get more money in equity and for their apartments. So what does the state legislature do? It responds. There's a lot of public apprehension caused by these rapid rent increases, and you have at the same time an inadequate supply of affordable housing. So you come to the Emergency Tenant Protection Act of 1974. So there are a lot of eerily similar, or eerily, there are many similarities between the ETPA, its promulgation, and the promulgation of the recent HSTPA, because as Mayor de Blasio, as many city officials, over the course of the last, I would say, at least 2 years, have been clamoring about the lack of sufficient housing, particularly on the affordable housing side. Okay, and that clamor became much more definitive and clamorous, if you will, towards the end of the sunset period, which was June 13th of 2019, right? And the next day, the HSTPA was passed, which we'll take a very close look at here in a little bit. So the ETPA provided for also a stabilization system in Nassau, Rockland, and Westchester counties, in municipalities which chose to adopt those regulations based on a housing emergency, meaning that the vacancy rate was less than 5% at that time. The act also substantially amended the New York City rent stabilization law, and it ended the vacancy decontrol provisions of 1971. The legislation that applied to rent stabilization. And then here we have in New York City, the ETPA placed buildings with 6 or more units completed between March 11, 1969 and December 31st, 1973 under rent stabilization for the first time. So here you see it again, but in a different context. And I'm talking specifically about rent stabilization now. You still have this mathematical formula. It still applies to buildings with 6 or more units, but now the date of construction shifts to bring these additional apartments under the penumbra of rent stabilization. In addition to that, rent-controlled units and rent-stabilized units in buildings with 6 or more units and deregulated by vacancy decontrol were re-regulated and placed under stabilization. And the vacancy decontrol provisions for rent-controlled apartments remain in effect, and these units either became stabilized or decontrolled on vacancy. Then we fast forward about 10 years later. In 1984, you get the Omnibus Housing Act, and it brought the whole system under state administration. It significantly strengthened tenant protections through enforcement of rent registration with the Division of Housing and Community Renewal, DHCR. So this date, 1984, very important because that is the first date when you really have records starting to be maintained and government mandating that landlords maintain these records, okay? We're talking about records related to the apartments, what kind of repair or upgrades were made to the apartments. That becomes important, as we see here later, because it allows landlords to take out apartments, take them out of rent-regulated status and turn them into free market units when certain threshold figures for improvements were found to have been completed. All right, and the DHCR, obviously still a very important agency in the context of landlord-tenant law here in the city. They generally have concurrent jurisdiction with the Supreme Court on issues of deregulation, illegal deregulation, and for rent overcharge cases and the like. And other things as well. In 1993, you have the state legislature renew rent regulation, but it specifically gives landlords a carve-out to deregulate vacant apartments that had a legal rent of over $2,000 if the apartment became vacant. So this is an extremely important point here. All right, the landlords use their ability to raise rents by making improvements to apartments in order to surmount this threshold following a vacancy. Again, you have the legislature stepping in a few years later, in 1997. The new law made it even easier to deregulate by raising this vacancy bonus. All right. The amount that a landlord is allowed to raise on a vacant apartment, that's how it's defined, and it's up to 20%. So I gave you a little example here in the notes. If you have a tenant that's paying $1,000 and they vacate the apartment, the maximum rent then automatically gets bumped up to $1,200, and the landlord only needs to do enough renovations to raise that rent to $2,000 in order to get it deregulated. So it was a pretty easy test to meet. And the apartment doesn't even need to actually rent for over $2,000 in order to qualify for deregulation. So in the years following 1997, you have hundreds of thousands of apartments that are coming out of deregulation. In 2003, the legislature simply extends the sunset provisions until 2011. You have the preferential rent loophole also created under this 2003 renewal. And in 2011, Cuomo, our current governor, extended the rent laws, and there were some minor pro-tenant amendments that were secured, such as harassment and the like. But many people on the tenant side and in the tenant camp will give you vociferous opposition on this and point to the 1993 and especially the 1997 laws, which they believe were improper, were too lenient, and improperly allowed, and many of them fraudulently, tenants' rights activists claim, fraudulently were made to come out of regulated status. Whether the repairs were falsified, whether the figures for the repairs were doctored. Many tenant activist groups believe that the alleged repairs that the landlords reported to DHCR in connection with those apartments that ended up being deregulated were simply made up, that they didn't pay the contractors for them. And there was a number of reports. There were a number of reports that came out. And it's been confirmed, especially with the Stellar Group, which is a very big landlord and developer, has a lot of properties. There were reports that confirmed many improper deregulations within their portfolio, and there were others as well. And I think that those bad apples, so to speak, were a lot of what prompted the current changes and modifications that came to be and were born into the HSTPA. All right, so as I said, June 14, 2019, just a little bit over a year ago, we have the HSTPA and the sunset provisions that extended affordable housing protections. Again, as I mentioned before, these can be traced all the way back to World War II, protecting the roughly 1 million apartments within New York City that were covered by the RSL of 1969 and the Emergency Tenant Protection Act of 1974. They were set to expire, so it came as no surprise that Governor Cuomo signed the HSTPA into law. And the day after it was passed, extending rent regulations statewide. Okay, I have the link here to it, to the actual HSTPA legislation. You're going to want to take a look at that. And it's broken down into parts, the HSTPA is. And each part deals with a specific section of the law. It promulgates new laws and new statutory frameworks, particularly for security deposits. There's a whole new section with regard to harassment. But if you look at the end of each part, it will tell you specifically when that particular section in the part became effective. So, for example, if you're dealing with a security deposit, the new security deposit law, which limits it at 1 month, you want to find out when that became effective. You simply scroll to the end of the part, and it will tell you at the end of the part when that particular section took effect. So it's very important to see that and to see when it became effective. You might not even fall under the HSTPA, depending on when the action transpired or when the lease was entered into. And again, as I mentioned a little bit earlier, this came on the heels of Mayor de Blasio's recent announcements that we were in the midst of an affordable housing crisis. Okay. But even if we are in a housing crisis, many people think that the HSTPA went radically beyond simply extending the prior protections afforded by the RSL. And I think if you're in both camps, whether you're a tenant or a landlord, I think you have to agree that there were radical changes made to the rent laws as a result of the HSTPA. There's no hiding that fact, right? The HSTPA, what does it do? It totally abolishes high rent and high income and high rent luxury deregulation and repealed vacancy increases and longevity bonuses. Beyond this, through the imposition of stringent caps, the HSTPA essentially eviscerated the rental increases from which owners previously took benefit under from the RSL by making individual apartment improvements and major capital improvements to their buildings. So what does this mean? It means that essentially now it's nearly impossible for a landlord to deregulate. You can only do so under a very, very narrow set of circumstances. In addition, the HSTPA strictly limited the recovery of regulated apartments for the owner's own use to one unit, insofar as the landlord can also show that it has an immediate and compelling necessity. All right. So previously, under the old law, an owner could recapture the rent-regulated apartment if the owner or the owner's immediate family member could demonstrate a good faith claim to occupy the unit as their primary residence. And what constitutes an immediate and compelling necessity? We have to look at the case law for that. That is created under case law. You have a few cases here on this issue. Under the prior law, just I think for purposes of example and to give you a little bit of context, a landlord or an owner could claim to be restored to an apartment if their child, let's say, had to attend school in the city and they wanted to move in. Let's say they were living in Jersey and they wanted to move into the city for their child. That would typically suffice under the old law. Well, probably not anymore. You look at this case here that I've cited. It's also in your materials. It's Exhibit 1. It's the Zagorski case. Zagorski v. Makarak. And so far, it's the only reported case on the issue. The tenant prevailed. The owner's mother and brother, having a mental illness, was found not to be immediate and compelling in this context. And this case was actually decided by Judge Wang, who I wrote an article with a few months back on the HSTPA, specifically with regard to evictions and staying evictions. And if you look at this case, take a look at the language of the case, and you'll see here that the petitioner, the owner-landlord, claimed by way of an attorney affirmation that he sought the subject apartment for his mother and brother, both of whom suffer from some unspecified mental illness. Okay, and the court here in the Zagorski case pointed out that the recent decision in Dugan, which we're going to be looking at momentarily, found that the pending claims withstood constitutional scrutiny because the legislature's enactments carry an exceedingly strong presumption of constitutionality. Okay, so on a going forward basis, it's tough to overturn the HSTPA. However, as we'll see post-Dugan in the Regina case, which we're also going to be taking a look at here shortly, the prior formulation of the HSTPA for rent overcharge cases that were retroactive in effect were held to be unconstitutional. However, the current framework under the HSTPA for prospective rent overcharge cases withstood constitutional scrutiny. So there are several cases now pending in federal court over the constitutionality of the HSTPA as a whole. One of the big claims are what we're looking at right now, owner's own use. And part of the claim for overturning that particular provision on constitutional grounds is that it is a taking. Landlords are effectively making the argument that the government is taking away their apartments by essentially eviscerating the owner's own use provisions under the old rent stabilization laws, meaning that owners can't now take the benefit of their own property unless they meet this immediate and compelling necessity standard, which seems to be an extremely high bar. At least based on the current case law. And we're going to see this continue to develop as we go forward. So it'll be interesting to see how the case law molds this particular aspect on owner's own use cases. All right, here now we've come to the point in the lecture. We're going to discuss the both sides of the laws from both perspectives here. And given these tremendous changes to New York's rent-regulated landscape that were caused by the HSTPA, tenants are now armed with much greater weapons to combat landlord abuse. And generally, the tenants groups say that this comes in the form of strong arming buyouts and harassment. So we have the tenants groups that are championing the new law. It levels the playing field against their more powerful landlords who have much deeper pockets. One of the main reasons for making it virtually impossible to deregulate under the HSTPA was, as I mentioned earlier, to deter this widespread illegal deregulation of the rent-regulated housing stock, where owners were simply making up the improvements that they were making to the apartments to take them out of deregulated status in order to meet those monetary thresholds. So invariably, the tenants groups say that this has led to hundreds of thousands of regulated units improperly coming out of regulated status. It's only worsened the affordable housing stock in the city and our housing epidemic. On the other side of the coin, you have the landlord groups claiming that the HSTPA will have disastrous financial consequences on New York's entire economy, and that the law now de-incentivizes apartment improvements by owners, which will now predictably deter repairs, leading myriad units to fall into disrepair. Okay, you're stripping the owners with the ability to augment rents after making improvements, and therefore the landlords are going to simply stop making those improvements, right? It's a matter of pure economics. If I'm a landlord and I can't deregulate a unit, what incentive do I have to put any money into that unit if it's not coming back to me in equity, right? So, and the proof was sort of in the pudding here. You have landlords, such as the Blackstone Group that announced a couple weeks after the HSTPA was passed that it stopped improvements on 11,000 units in Stuytown at Peter Cooper Village. And that's a testament to this. And, you further have landlords charging that rent regulation does not assist affordable housing, but rather it protects wealthy, older tenants who may have acquired the units a number of years ago, either through their family. And there have been studies about this. I read a report in the Wall Street Journal a few months back, and they did a pie chart analysis showing the differences in the rents between boroughs in outer Manhattan, and the rents between regulated apartments and free market apartments in the outer boroughs is negligible. There's not much difference at all. So, the landlords, I think, at least in that vein, rightfully say where's the conceptualization here of the laws? Why did the legislatures do this when their goal was to protect affordable housing, when that's not really what it does? And we talked about some of the constitutional cases that we're closely monitoring here. And now we're about halfway through the lecture already. We're going through, I'm going to read out the code that we have here. The program code. In order to comply with New York regulations, attorneys looking for CLE credit in New York will need to be able to provide a code. This code is not intended for West Legal Ed Center audience, either live or on demand. I will read this code twice and only twice, and cannot repeat it or email it to you. So please make note of it. The New York State code number is M as in Mary, D as in David, 30166-62920. I'm going to read the code one more time. Your program code is M as in Mary, D as in David, 30166-62920. Okay. Let's continue on here into the lecture. This is a big case, the Dugan versus London Terrace case. It's in your notes here as Exhibit 2. This was a First Department Appellate Division case, and it was brought by a group of tenants as a class action litigation against the landlord of a 10-building complex comprising of about 1,000 apartments. And they were challenging the deregulation of hundreds of the complex's apartments. So you're going to want to take a look at the facts of the London Terrace case here. You look back, the complex was constructed in 1931. Therefore, as we saw earlier, most of the units were built before February 1st, 1974. So they were subject to rent control. But then you have the 1974 Emergency Tenant Protection Act, where upon vacancy, the rent-controlled apartments then segued into rent stabilization. And since 1974, there was a blend of both types of regulated status apartments. So that's why this is a nice case to look at, and the facts link up nicely with rent regulation. You have both sets of mechanisms of regulated status. Then you fast forward to 1993, the landlord starts deregulating apartments. Again, we looked at the 93 and changes in the 97 law, which allowed quite liberally deregulation. Then in 2009, you have the landmark Roberts v. Tishman case. I didn't include that in your materials, but I gave you the citation. You should look this case up. Roberts is a landmark decision. And it held that rent-regulated units could not be deregulated where the building owner received tax benefits for building rehabilitations under the J51 tax abatement and exemption program. Furthermore, the Roberts Court ruled that apartments receiving J51 also needed to be registered with DHCR. That's the agency we looked at earlier. At the very least during the period that the owner continued to get the tax abatements. Then on July 1st, 2003, the London Terrace had already deregulated close to 100 apartments within the complex when it began receiving J51 benefits in connection with qualifying improvements. And despite the receipt of these benefits, the owner failed to revert the many units that it had deregulated, and in fact continued to deregulate during the period that it still received J51 benefits. And it did not register the units with DHCR, failed to adhere to the rent laws in calculating the legal rents through DHCR, So shortly after Roberts came down, a group of tenants at the London terraces consolidated their cases. They got class action certification. This Maddox case also holds that as tenant groups, you can bring these cases as class action cases, these rent overcharge cases. In defense, the landlord maintained that Roberts could not be applied retroactively, or shouldn't be, because it would offend due process, because the landlords claimed that they were relying in good faith on the interpretation of the prior statutory framework that allowed deregulation. Didn't matter. The holding in Dugan, the court upheld the lower court's decision, found that Roberts is to be applied retroactively in these rental overcharge cases. That's in line with Gersten and its progeny, because Roberts simply interpreted a statute that had been in effect for a number of years and did not establish a new principle of law. So since Gersten, the First Department has categorically rejected due process challenges to the retroactivity under Roberts. And under the prior law, the First Department frequently limited the review of the rental history to the 4-year period preceding the filing of the overcharge complaint. And they typically did not permit additional information outside of that in determining these overcharge cases. Grimm being a very big one, also Radin. So I've listed and cited those cases. Dugan, however, resolved this split at least momentarily up until Regina. Dugan ruled that the HSTPA now explicitly provides that a court shall consider all available rental history, which is reasonably necessary to investigate overcharges and determine the legal regulated rent. So in this ruling, the Dugan court eviscerated the prior 4-year look-back period and replaced it with an ad infinitum look-back. But this changes. When the Regina case, which we'll look at next here, came down, it reversed this part of the ruling in Dugan. Dugan is still good law. And specifically, take a look at the highlighting that Dugan provided in terms of pointing out the comprehensive set of collective records that can be examined in order to determine legal rents and overcharges. Okay, and that's set forth here. And this is a non-exhaustive list. Rent registration and other records filed with DHCR or other governmental agencies, regardless of the date in which the information refers. Orders issued by government agencies, records maintained by the owner or tenants, and public records kept in the regular course of business by any government agency. So accordingly, the Dugan court remanded the matter back to the lower court for purposes of determining the legal regulated apartment rents and the methodology for calculating the statutory damages from 6 years prior to the commencement of the suit. All right, so what's the impact here? So under Dugan, there is no limit on the examination of rent history to determine the legality of a rental amount charged or to prove that a registered rent is reliable under the HSTPA. Again, this is still good law prospectively. However, according to Regina, which we're looking at next here, retroactively, it is unconstitutional. And I have a footnote here to the article that I wrote in December of 2019 on the rent overcharge laws, on the sweeping reforms that came about as Dugan. I cited in my article, certain problems that I thought would come about and were why they were constitutionally offensive or odious, and the Court of Appeals agreed with me as Regina came down and reversed the retroactive portions laid out under Dugan. All right, so what does this all mean? The tenants were entitled to review DHCR rent registrations going back to 1984 as far back as the DHCR maintained those registrations. But again, remember, this is no longer the law. Dugan was reversed on this point. They can only go back for 4 years prior to the rent overcharge complaint, which is what the prior law was. So now we come to Regina, and you're going to want to read Regina. Regina, although it's a very, very well articulated and well written opinion, it's very long and dense. This came down not too long ago. It's still pretty fresh. April 2nd, 2020. The New York State Court of Appeals issued a split decision, and it was on a string of 4 rental overcharge cases. That's Exhibit 3 in your notes. And as you can see, the Regina Court ruled that the HSTPA's mandate compelling owners to produce their entire rental history from the beginning of time in connection with defending against these rental overcharge claims would be fundamentally unfair, right? Because the owners didn't have such a legal obligation before. So how could they fairly be now charged with maintaining those records going all the way back? All right, so what happened? Regina has lifted a chill. As soon as the HSTPA came out and Dugan came out shortly thereafter, it produced a chill especially in New York City over the purchase and sale of rent-regulated buildings. Nobody was touching them anymore. People weren't selling them. Nobody wanted to buy them because it was considered a toxic asset. You didn't know what you were buying. So Regina has lifted that chill, thankfully. And here I get into the doctrine of judicial review. Now, again, you should all look at the Regina case and read it, but certainly we have to read Regina in conjunction with the doctrine of judicial review, which was espoused by our great Chief Justice, John Marshall, probably the best Chief Justice that ever walked on the earth. He enunciated over 200 years ago in the Marbury v. Madison case the doctrine of judicial review, and the contemporary framework for due process challenges also is explicitly laid out in the Regina decision. And conversely, there are also certain cases in which you are allowed to have retroactivity, right? There are certain cases that say that's okay. You look at the Child Victims Act, right? It's okay there. And I have that case also. I've annexed it to the materials here so that you can take a look at some of those cases where you do have certain retroactive claims that are actionable. All right, you look at the 9/11 cases, Matter of World Trade Center versus Lower Manhattan. I think that's the one I provided in my notes. The New York Child Victims Act, which was recently passed as well. And you're looking at rational basis scrutiny here. There's some other cases that I've cited you also want to take a look at. And the United States Supreme Court has made it crystal clear that it is much easier to satisfy rational basis test over a statute's constitutional validity for prospective as opposed to retroactive application, because the elements of notice and surprise are naturally dispensed with. So that's a big point. And I think that point alone is really all you need to take from Regina and understand it based on a constitutional framework as to why it's offensive, right? You have legislation that's passed. You put the world on notice now going forward as to what the law is and what your duties as a landlord are to maintain records. And you better make sure as a landlord that you are keeping every single document related to that apartment's rental history and you're scanning it in fastidiously to a system, because now, landlord, you're on notice. This is the law. This is now what you're dealing with. So you better make sure you maintain every single paper. Every payment that's made to a contractor for a material repair, an improvement, you should be holding on to. Certainly in the hopes that one of these current cases finding other aspects of the HSTPA unconstitutional, specifically with regard to deregulation and allowing those apartments to be deregulated in the future. Landlords are all across the country are taking a close eye on that. But why is it offensive retroactively? Because before this law, landlords only had an obligation to maintain those records for 4 years. So it is clearly offensive and a matter of extreme surprise for a government to come back and now say, okay, landlord, we didn't care that you had 4 years before. We're throwing that out the window. You should have maintained those records since the beginning of time. So it's very, clear to see why the HSTPA, particularly with respect to the retroactive applicability for rent overcharge cases, was so offensive, and why Regina struck it down. Okay, so I go through some of the procedural history here. I lay it out very nicely in Regina, what we just talked about, the prior look-back period, the changes that were made, the holding in Regina, and post-Regina, the fallout from Regina. And again, it opened up this chill that was imposed over the purchase and sale of rent-regulated buildings. Now, at least owners have a modicum of figuring out what their potential exposure and liability is. So it's really caused a great deal of ease in knowing that, and is what reopened the market for the sale of these buildings, which is a good thing for everybody. It's good for the economy. Certainly, we don't want these buildings sitting around and continuing to be dilapidated further. Now, again, last point here on this Regina case is that some landlord groups, I think incorrectly, believe that Regina is the first step in the Court of Appeals overturning other aspects of the HSTPA. I think it's wishful thinking. I wrote an article back in October of 2019 on just this very issue. I've cited it here. It's footnote 4 on the notes if you want to take a look at that article. But for the reasons articulated in that article, I don't believe that the prospective applications that were promulgated under the HSTPA are going to be impacted at all. I think this is just a one and done by the Court of Appeals. I don't believe that they're going to overturn other aspects of the law. Remember, especially with regard to real property, the case law holds that legislatures have wide discretion in imparting rules that respect their real property within the confines of their jurisdictions. So here are the practice tips I think we went over just recently, is that if you're a landlord now, you got to hold these records. You have to have an electronic system, a cloud, a third party, a manager, whatever it may be, but you need to ensure that these records are being held and are being held fastidiously for the long term going forward. You also have the abrogation of the no mitigation rule that was espoused under the HSTPA, and that overturned partially the holding in Holy Properties, which is one of the most often cited cases. New York, I don't know if anybody knows this, but New York is in the extreme minority of jurisdictions where if you have a lease between a landlord and the tenant leaves early and defaults and leaves before the end of the term, a commercial landlord does not have to do anything to mitigate its damages. It could stick its head in the sand and sue that commercial tenant for all of the rents that are due under the lease going forward. It's got no duty to mitigate. Okay, New York is in the extreme minority in that respect. Most other states require the landlord to mitigate. But the and that apply, and holy properties was extended also to the residential context. However, the HSTPA did away with that. The HSTPA abrogated the no mitigation rule in the residential context. So while holy property still is good law with respect to the commercial realm, it is no longer good law in the residential context. This means that in a residential setting, a landlord has an affirmative duty to mitigate. If the tenant leaves as a result of this pandemic during the last several months, the landlord has got to advertise it, market it. Now, given the pandemic, a landlord also has defense, on that front now, because it's very difficult to relet an apartment. So that's what I'm arguing if I'm a landlord, right? But it's going to be interesting to see how this plays out. Certainly, once the dust settles from the pandemic and things go back to some level of normalcy, this is a big one for landlords all across the state, because they now have to, get a broker and make sure that they are reletting these apartments. See if we have any questions. Okay, moving right along. Here are some practice tips too that I've given you for mitigation. You might want to take a look at them depending on who you represent, which side you represent. A big point of contention has also been the broker's fees, 238-A. There's also litigation on this particular component. You had the city councilman. It was led by Keith Powers and Carolina Rivera. They introduced a package of bills to the city council in February of 2019. It met with vociferous opposition from the broker community. And they wanted to limit the amounts to be paid to 1 month for broker fees. And there is actually a pending case. Again, it's closely being monitored. That's up in Albany to see how that turns out. And I've cited the entire limitation on fee provision here for your edification. Also a big one, security deposits. Under the HSTPA, they apply to current leases in effect. And a landlord cannot now charge more than 1 month's rent, as in for security of the lease. There's also a very complex framework which details the repayment of the security and what tenants and landlords must do at the inception of the tenancy. So it's very, very important, especially if you're practicing in the landlord-tenant realm, real property realm, you're doing transactions, lease transactions, to know this particular aspect of the law. You want to be very well versed with this, the procedure that's laid out now for the inspecting of units at inception, and all the statutory damages under the new law, including punitive penalties if it's found that the landlord has willfully violated these security deposit provisions. And those security deposit provisions, as I mentioned earlier, if you look at the end of each part of the HSTPA, it'll tell you when the effective date of that particular law or statute is. In this case, the new security deposit provision became effective on July 14th, 2019. It was 30 days after the law was passed, and it applies to any lease or rental agreement or renewal of a lease or rental agreement entered into on or after such date. So I got that by looking at the end of the section where you find the security deposit law. The end of the part will tell you exactly when the law became effective. And I've also cited the security deposit law here for you so that you can take a look at that and look how comprehensive it is in terms of documenting the condition at the inception of move-in and the notice and procedural requirements that have to be followed upon turnover of the unit and return of the security. So as a landlord, you want to be especially careful because you can be hit with, very, very big statutory and mandated penalties, including possibly punitive damages. I've also included here some legal screening for tenant applicants under the HSTPA. And now we're, getting towards the end of the lecture here. I wanted to get into some of the COVID-19 related issues that have, come about here. And I've put in here a lot of details about the destruction that's been caused by COVID, not only in terms of economic factors, but also on a human body count level. I mean, we had 50,000 plus some cases of infections for COVID, again, come out. And they are increasing rapidly, especially in California, Texas, and Florida. So it looks like we're headed towards a second wave here. And I have it here in the notes, but Fauci, who is our medical head here in the U.S., had opined that there was going to be 200 to 240,000 Americans that were going to die from the virus. And that number looks like it's going to be head on, or it may even be surpassed. But it continues to, the death toll continues to mount as no effective means to combat the virus have currently been discovered. And scientists are working around the clock to make that happen, but it's certainly going to take more time. Many people think it's going to be September or later at the earliest. And I have some good notes here, some good historical references in the materials for you. The governor orders, the governmental orders, specifically 202.33, which enlarged the executive order 202.10's gathering ban, which explicitly permitted gatherings of less than 10 people or more, as long as the social distancing and disinfection protocols were adhered to. You have some of the comparisons here with the 1918 flu. But for our purposes, I wanted to get into a little bit, and we're heading towards the end here, but I have a couple more minutes. I'll finish up on protocols. So it's very important for drafting protocols for residential buildings. You want to make sure as an owner that you have these in place, that they're mirroring the governmental orders on what's safe, the CDC guidelines, Centers for Disease Control. And in fact, there are many buildings in the city that have come up with these protocols. And it's certainly highly recommended that if you're an owner or a landlord, you do compose these protocols, you hang them or place them in the common areas of the building where everybody can see them walking in and out. You certainly want to make sure that you have hand sanitizers at the front desk in the common areas, and that if they're empty, they be refilled immediately. You want to make sure that cleaning and disinfecting is happening in your building at least several times every few hours if it's possible, but as much as your manpower can dictate. And when you're drafting these protocols, you should bear in mind that whatever policies are adopted, they closely resemble, as I said earlier, if not mirror, the governmental orders that are in effect. And you apply them equally to everybody in the building without exception. Here are some important privacy considerations, privacy and confidentiality considerations during COVID. So, the answer is no. You can't legally notify the rest of the building that one of the residents has COVID, right? It's offensive under the ADA. There may be certain other confidentiality implications at play, but you certainly as a landlord do not want to expose yourself to liability, especially now when you're likely not getting rents from Some, or there have been reports that have said 30 to 40% in some buildings are not paying the rent. So, in addition to that, you don't want to add insult to injury and also be hit with a lawsuit for violating a resident's confidentiality. Now, that does not mean that you should not contact the Department of Health. If you are aware, and the CDC, if you're aware of somebody contracting the disease within the building who was using the common areas, the elevator, the stairwells, etc., you do want to notify the requisite health agencies, the DOH in particular, and CDC, to see what steps should be taken, if any. All right, clearly you're going to want to quarantine people, especially building employees, super, doormen. You can also move for emergency relief if there's a violation of the rules by a renegade resident. I had one. If you look at the footnotes here, that was my case. I made the news. I was in the Post. I was in CBS News. I actually made international news. I obtained the first emergency temporary restraining order against the renegade resident who was violating the building's COVID-19 protocol. And I got an emergency order from the court restraining this person from further violating the rules. Okay, I have the relevant standards here for what needs to be shown in order to get such a temporary restraining order. The big case is Nobu Next Door. I've given you the case in the notes here. I've included it. So now we've come to the end of the lecture. Although COVID-19 is still nascent, the destruction that it's caused is certainly unprecedented on so many levels. And as a landlord, you really want to make sure that you're taking the proper considerations and promulgating the proper rules to effectively deal with it. And again, please, if anybody has any questions about any of the cases, any of the developments, applicability, etc., please do not hesitate to call me. I have included my email and my cell phone number in the lecture materials. And thank you so much. Be safe, everybody. Stay healthy. And off to the next time. Talk to you soon. Hey, Charles, Massimo D'Angelo here. Please give me a buzz on my cell when you can. 732-232-1617. Thanks.